Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. My name is Dan Balkaran, an employment lawyer at the law firm of Samfiru, Tumarkin, LLP, and I will be your employment lawyer for the next half an hour. Before we begin, just a quick housekeeping note. I'm currently broadcasting to you from Vancouver's beautiful West End. We're in the middle of a horrendous windstorm right now. I've already lost my power and internet connectivity once this morning. If that occurs again, I may drop off accidentally, but that's the reason why. Okay, before we begin, just a quick primer. For the last couple months, actually, a couple more things, housekeeping matters. Sorry. If you need to contact us, you can do so by going to employmentlawyer.ca. That's everything about our firm. You can email us at help@employmentlawyer.ca, and you can always give us a call at 1-855-821-5900. Okay, great. So in the last few months, before the Christmas break, and I hope all of you had a wonderful holiday break and a happy new year. In the last few months before the holiday break, almost every question, 99% of the questions that I received through this Facebook Live, YouTube streaming Q&A were about vaccine mandates. I just want to do a quick primer on what those are and what that means. So the word mandate is kind of confusing. So if your employer imposes, changes work policy or imposes a policy upon you saying that you must be vaccinated in order to continue to remain employed, that is different from a government mandate. So in the event that your employer terminates you because you haven't been vaccinated, depending upon your own personal legal circumstances, you very likely have a claim for severance, and that severance claim, depending upon your legal position, could be very substantial. But if there's a government mandate covering your specific employment sector, saying all employees of this particular sector must be vaccinated, this is from the government, properly papered through a provincial health order or legislation or regulation, saying that you must be vaccinated in order to work in this particular employment sector. If you're not vaccinated at that point, you're going to lose your job, and your right to severance is effectively extinguished. So that's the difference between the two things. So, and government mandates, there's sort of a patchwork of them across, provinces, all the provinces, and also at the federal level. So, if you are in a position where your employer may be terminating your employment because you are not vaccinated, I certainly encourage all of you to speak to an employment lawyer. It's just too complicated to try to go this on your own without getting legal advice. Again, you can contact us at help@employmentlawyer.ca and 1-855-821-5900. Okay, great. All right, there you go. Okay, we've got one question so far, and it's an interesting question, actually. Are third boosters mandatory now or just highly recommended? Well, I don't know what you mean by mandatory. So government mandates themselves, I don't think, have contemplated boosters, but that would be dependent upon the individual text of all of those pieces of legislation or provincial health orders. I think the language, and it's been a while since I've looked at it, but I think the language talks about, officially recognized vaccine, right? So you can't get Sinovac from China or the Russian vaccine, but, Johnson & Johnson or Pfizer or Moderna are properly recognized vaccines. And, I don't know if it contemplates the amount of dosage, but it would not surprise me if in the coming weeks, as boosters move into becoming, I guess, a medical consensus saying that you need boosters in order to deal with the emerging, properly protect yourself and others from the emerging Omicron variant. I would not be surprised if the mandates themselves change their language with respect to boosters. And then, as always, if employers have individual employment policies with respect to vaccines, How they define it is up to them. It's just, do you have a right to severance in the event that you're terminated because you're not getting a booster? So I hope that answers your question, Melissa. Let me know if it doesn't. Oh, here's another question from Melissa. I work in a congregate setting. Work is mandating a third shot. It is still considered fully vaccinated 2 shots. Well, I don't know what a congregate setting means. Congregation, like church affiliated. Again, what I said earlier, work with mandating a third shot. Well, I mean, your work can do what it wants to do, right? Your only legal right in the event of your termination is severance, and whether or not you are precluded from that severance by a government mandate is something you certainly want to talk to a lawyer about. If you're fully vaccinated 2 shots, is the third shot something you don't want to do? You'll have to look at a variety of factors. With all of these things, I always tell everybody, you need to evaluate your actual individual position and the effect of losing your job. Like if you're 25 and you don't want to get vaccinated and you lose your job, well, I mean, you've got your whole career ahead of you. But if you're, the example I always use, if you're 53 making $85,000 a year with no university education, you can't lose that job. It'll be just a disaster, a financial disaster for you in terms of your potential retirement. And so you have to take a really hard look at it. And if the vaccines are a non-starter for you, well, is there some way you can reach accommodation with your employer by working remotely? Or if there isn't, is it something you want to actually consider to compromise your position and actually get the vaccine, or in this case, a third shot? So, but Melissa, I think you should talk to a lawyer. I think you should call us 1-855-821-5900, help@employmentlawyer.ca. I think you need to get legal advice with respect to your question. Okay. Specific tailored legal advice. And that just goes for everybody on here. I'm giving you sort of general off the cuff knowledge with respect to your individual questions, but that doesn't replace proper legal advice, which analyzes your specific legal position, including jurisdiction and a variety of other things. So, okay, Mark asks, can an employer change the percentage of commission you make as a result of the pandemic? Well, again, the employer can do whatever it wants. It just depends if what they've done is tantamount to a constructive dismissal. So, if your employer lowers your compensation effectively by 10% or more, I mean, to be safe, 20%, but by 10% or more, that could be considered a constructive dismissal, i.e. your employer's actions by reducing your pay are tantamount to a termination. And therefore you can claim severance, but you won't have your job anymore. So you have to assess if the amount of, like, if they've lowered your commission and you take home 50% less money, you probably want to claim constructive dismissal, get your severance, and go, depending on what your employment contract says. However, if they've lowered it by, your take home is lowered by 8%, you've been there for 10 years, and this might pass when the pandemic changes, then maybe you want to stay. So Mark, as well, I think you should talk to an employment lawyer for sure. It's to really assess your individual position, the amount of commission the amount of your take-home pay that has been lowered. Again, employmentlawyer.ca, 1-855-821-5900. Okay, let's keep going here. Can my employer force me to get a PCR test even though they're now only available to the medical field? This sounds like an Ontario question. I haven't been as glued to the news as perhaps I should be. I know that there's a shortage of tests in Ontario. So what a lot of businesses, so actually this is a great question, because I was just dealing with this recently. So what some employers are doing now is they're saying, because they're staring staffing shortages full in the face. And so what they're doing is they're saying, well, we have a vaccine mandate. You must be vaccinated in order to work here. However, instead of getting the mandate, you can do testing, rapid testing, PCR testing at a certain amount of intervals, and then you don't have to get vaccinated. And so first part of that analysis is, well, can you claim that by imposing that requirement on you, or if you refuse to get it, they terminate you, that you have a right to severance? Well, theoretically, it should be possible, because you were able to do your job up till 5 minutes ago without getting the testing. So why is it all of a sudden now a fundamental term of your employment to get the testing? But on the other hand, it's one thing for an employer to say you must put this foreign substance into your body. That seems to be perhaps a bridge too far in terms of not getting any severance in the event that they terminate you for not getting the vaccine. But it's entirely different when you're talking, or it could be entirely different when they're talking about giving you an alternative that isn't as invasive, which is the testing. So I think that if you were to try to advance a severance claim and your employer has offered you the ability to get testing in an alternative to being vaccinated, I think it's a really risky case, and you'd want to take a look at that. Now, in British Columbia, and I think in Ontario, if you're a provincially regulated employee who's not exempt, like a professional, like an engineer or an accountant or something like that, they can't impose the cost of, your employer can't impose the cost of business upon you. So they can't make you pay for your PCR tests or rapid tests. Excuse me. They can't make you pay for that. And if they do, then you have a constructive dismissal case and you can go after severance. Now, in your case, Rachel, they're saying your employer, I mean, there's not enough information here, but you're saying that your employer is forcing you to get a PCR test, even though they're not available. I assume they're making you get the PCR test. I mean, what I would say to them is, yeah, I'm happy to do the PCR test to go to whatever interval you want, but you can't obtain one right now. Please give me the PCR tests and see what they say. David, can I get constructive leave? They don't pay 1 to 3 days of lost wages. So technically, any interruption in pay, unless you specifically agree to it in your employment contract, is a constructive dismissal. However, would I want to ride into court saying, well, you didn't pay me for 3 days, but then started paying me again, I claim constructive dismissal? Probably not. Your loss isn't really that significant. So maybe, but also, David, if you do that, you lose your job and you might want your job. So I probably not the best case to take a shot at. Okay. Jay, being unionized, I've been laid off since 2020. Regarding my severance and infectious disease leave, can my employer withhold severance? Been with the company for 7 years. If you're unionized, Jay, you need to talk to your union representative. Your entire rights under contract are governed by your employment rights are governed by your collective bargaining agreement, subject to labor relations legislation. So I can't answer that question. I think you need to talk to your union representative, see what they say to you. Okay, JC says Johnson & Johnson is stated as being a single dose. Some employers and others in other settings are requiring 2 doses. How should I deal with potential related conflicts? An employer requires double vaccination. This is an interesting question that I haven't had before. So somewhere provincially and federally, there are going to be, as I was saying, sort of at the top of this Q&A session, there are going to be government definitions of what is officially considered a vaccine, an acceptable vaccine, and what isn't. So again, to use the example, generally Johnson & Johnson, Pfizer, Moderna definitely accepted and government approved. Sinovac from China, the Russian one, I can't remember what it's called, and there are a whole host of others. Those are not approved. They're not officially approved. So, if your employer is saying you need to have 2 doses, I think your first step, and you don't want to get fired, right? So you want to come in friendly and amicable and say, listen, I've already got my 2 doses. It just came in one shot from Johnson & Johnson. Here's the government language saying, yeah, this is the same as 2 doses. Are we good here? What do you need me to do? Et cetera. And try that. Like you don't want to run a situation where you get fired. However, you do get fired for not getting 2 doses, you'd certainly have a severance claim. Are gig workers that drive for Uber Eats or skip the dishes really independent contractors? It's a great question. I know that there was a referendum in California on that. I can't remember how that worked out. The test, and I actually am not familiar with whether or not they are in different localities in the provinces. However, the test for whether or not you're an independent contractor, a dependent contractor, or an employee has to do with the degree of dependence and control, right? So, are you your own business? If you're a gig worker, your own business. Who controls your schedule? Whose tools are you using? Do you have to wear the Uber Eats logo on yourself? Profit and loss versus getting a regular wage, etc. I think that's an interesting question. I don't know if it's been. I assume it has been in one of the jurisdictions, provincial jurisdictions in Canada. We tend to side more with their dependent contractors or employees. I'd probably lean towards dependent contractor and employee, but I'd have to take a look there at the cases there, because I can see there being valid points on both sides. So I'm sorry I can't answer your question more thoroughly, other than to say that there is a test for that, and I suspect that they're probably not contractors. But don't quote me on that, because I haven't looked at the applicable case law. PCR tests are now banned by the CDC and FDA as of December 31st. Be informed, people. Okay, well, that's not a question, Carl. That's just sort of a statement. If you have any questions, let me know. Belinda, is there a reasonable amount of testing an employer can request for unvaccinated staff? Is there such a thing as too much or too little? Well, that's an interesting question. I talked to a guy the other day whose company wants him to get tested every 3 days. I do think that is onerous, but is it sufficient enough to say that if he doesn't get it, he's terminated, that the company didn't have just cause to terminate him, i.e. he can't. Just cause just means you don't get any severance. I think the real test there is actually who makes you pay for it, right? Particularly if you're a provincially regulated employee who's not subject, who is subject to the Employment Standards Act of, say, Ontario or British Columbia. I think if they make you pay for it, then you have a constructive dismissal claim, and then you can go after severance. For a lot of people, though, especially as the cost of the rapid tests come down, you have to evaluate again, because your only legal right in the event of your termination is severance. And for a lot of you, keeping your job is more important than that, particularly if you've been there for a long period of time and you've got a lot of equity built up. And equity is perhaps the wrong word, because it has so many different meanings. You have a lot of goodwill built up in your business. This is going to pass. Maybe you want to just get the tests, even if it's every few days, and get the tests, and then eventually this is going to stop being a requirement, perhaps. If it's every day, again, I think it really turns on if they make you pay for it. But I do hear what you're saying, that it seems like at some point that how many you have to get is a little bit, it goes to the onerous side. But especially with Omicron and its transmissibility, I think that'd be a difficult argument to make. And for a lot of you, if the testing is an option, you probably just want to do the testing for now. Even this is what I was going to say. Even if they make you pay for it, do you want to trigger a constructive dismissal? You might, depending on your individual legal position. And for that, call us 1-855-821-5900, help@employmentlawyer.ca. But you also might just want to eat the cost, especially because the cost of rapid tests are so much cheaper now. You eat the cost, you live to fight another day, and you reevaluate 6 to 12 months down the road. So, and again, for all of you, you may want to it might be worth it if you've got these questions and you're not sure what to do. Give us a call, hash it out with an employment lawyer. Okay, David, how do you prove wage discrimination? I get X amount, 5-year worker, another new worker gets X amount per hour. I think, well, first of all, you're talking about a human rights complaint, because they're discriminating against you on the basis of, you didn't say what it was, but race, sex, gender identity, ethnicity, religious belief, whatever. I always, when it comes to wage discrimination, I personally, I think that's it's an uphill battle. I think it's very, very difficult. The reason why I think it's an uphill battle and why I think it's difficult is because businesses are entitled to pay differential rates in order to achieve the outcomes they want, right? So if someone has greater qualifications, they can pay this person more, or maybe this person is a harder worker, or maybe they just realized, we were paying our employees too little, new employees too little, we had too much turnover, so now we're going to pay more, right? And maybe you get the short end of the stick on that, but you'd actually have to have evidence tying it to some form of discrimination, right? And this is where smaller employers, I think, have it hard. Like if I'll use myself as an example. If I worked somewhere where there were 5 employees, and I'm of Indo-Canadian descent, and everyone else there was Caucasian, and I was getting 15% less wage, could you make the inference that the argument that it was because of my ethnicity? Maybe, but it's a lot easier to make that argument when you're like in a 300 person setting, and and there's 20 people who are Indo-Canadian, and they're all getting 25% less than everybody else. That would be an easier argument to make. So I think that's a very uphill battle, because employers do have the right to pay differential amounts to incentivize production. So, Satish, can I sue my employer for constructive dismissal? Does IDO in Ontario not safeguard the employer? Laid off March 2020, seniority 20 years. Can I take up another job and still sue? Okay, there's a lot of questions. So first of all, Satish, you should call us right away. 1-855-821-5900. You're 65. You have 20 years of service. Depending on what's in your employment contract, you might have a very lucrative severance claim. I mean, the numbers that you quoted are very much so. Not up on my Ontario law enough. I will say that there were battling cases in Ontario about whether or not putting someone on IDLE, the infectious disease leave you quoted, whether or not you can still sue for constructive dismissal or whether it's not. I don't think there's been a full resolution on that. I also can't remember. IDLE is supposed to run out, at which point all those people are terminated. I don't know if that's occurred or not. Absolutely, you should call us. Like with those numbers that you're talking about, speak to an employment lawyer right away. Have your employment contract ready if you have one. Again, give us a call, 1-855-821-5900, because it's potentially too valuable to not kick the tires on, and you haven't worked for quite a long time because of the situation that you're in. Can you start another job and still sue the employer? Yeah. So if you have a right to common law severance, you'll have an amount of severance pursuant to a formula. So for example, he's 65. I don't know what his position is, but he's been there for 20 years. I'd probably ask for the maximum of 24 months. He's not going to get that, but I'd ask for the maximum. But if within that period of time he obtained alternate employment, whatever his earnings were during those 24 months or whatever we end up settling out for, that money is subtracted from his severance entitlement. So certainly you can do that. It's just dollar for dollar subtracted. In Ontario, while being on unpaid leave due to vaccination, can I start working full-time in another place? I just answered that question. That was perfect timing. JC, Russian vaccine is called Sputnik. I will take your word for it. Satish, I'm a non-unionized worker, and up to when can I sue the employer? You've got I assume the limitation period in Ontario is the same as British Columbia, so 2 years from the date of the action that resulted in your situation. So if you're placed on layoff, it'd be 2 years from March 2020. So you want to talk to a lawyer right away. Again, 1-855-821-5900, help at employmentlawyer.ca. Otherwise, you'd have to wait for your termination. Question from Ed. If my wife works 2 jobs and has lost one due to COVID, is she able to claim severance if she's still working 1 job? Yeah, so the way it works is if you're working 2 jobs and you lose one, you have a right to severance, and the money from this job, provided that you don't increase your hours, is not dollar for dollar deducted. However, if you do increase your hours, then that increase is dollar for dollar deducted. Okay, see if that makes sense. But you had those two jobs before, so it's not like one is replacing the other. But any job that you get in replacement of the job that you lost would be dollar for dollar deducted from your severance claim. Okay, Pam, I'm on temporary layoff, and my employer is asking for proof of vaccine. However, I've not been called to work. Excuse me, this is a very strange question. Do I need to tell them right now whether or not I am? Well, I assume that you're not, because that's why you're asking that question. Depends what you want. So if you don't tell them that you've been vaccinated, they might fire you, right? Like that, they can do that. And if you don't want to lose your job, then that's probably something you want to deal with. However, I mean, you're not working, so does it really matter? I mean, they're trying to assess. I mean, the reason why they're asking you is because they're trying to assess when people come back or who comes back, what their employment workforce is looking like in terms of vaccines, and then making staffing decisions from there. So, I think for all of you, and I know I sound like a broken record, but whether or not you if you haven't been vaccinated, and what's going to go into your decision is whether or not you have a substantial amount of severance coming to you. So you should talk to an employment lawyer. You should give us a call if you are in Ontario, British Columbia, or Alberta. Give us a call right away, 1-855-821-5900, employmentlawyer.ca, help@employmentlawyer.ca, before you make your decision. Okay, because if you don't tell them, or that your vaccine status, or you tell them your vaccine status is I'm not vaccinated, you're probably going to get fired. So, Robin, why are employers allowed to do whatever they want, and our only recourse as employees is severance? Because it's a very good question, because severance is a poor substitute for your job, but that's the law. Aren't there laws to prevent them from overstepping their authority, such as forcing employers to take medical treatments? So, your only legal right in the event of your termination is severance. But there are also human rights laws and occupational health and safety laws that restrict what an employer can do, right? Like an employer can't have you work inside of a vat of acid, or, can't discriminate against you on the basis of sex or race or what have you. But absent those things, or absent transgressing those pieces of legislation, Human Rights Code and occupational health and safety legislation, they can terminate you whenever you want. And your only legal right in the event of termination is severance. And we're lucky to have that, because Americans, most of them don't even have that. They're just out on the street. It has to be this way, because if it were any more expensive for employers to fire employees, as it is in Europe, for example, France, Spain, those kind of places, no one would be able to fire employees. And if you can't fire employees, the result is you don't hire employees, right? So, if you go back to the European fiscal crisis that happened for the mid part of the last decade, a huge part of that was had to do with, as a result of the crisis that was going on and the austerity that was going on, unemployment rates amongst youth and I guess youth, you define as 25 and down, we're up at 50% in some countries. Half of all people below the age of 25 above the working age in Spain, or I think it was Spain, were unemployed. And so, you need to, the rights of employees is always, upon termination, is always a policy balance, right? Because if it's too onerous, people aren't going to get new jobs. But if it's too light, like at-will employees in the United States, well, then you're just thrown out the street with no money and no job. And that could be obviously devastating, and so financially devastating. And so it's always a balance. But the short answer to your question is that's what the law is here. And those laws, I don't see them changing. But the way to change them is to talk to your local MLA. Okay, we're pretty much done. I'll see if I can take one more question, and then we'll have to wrap it up. So, I was a full-time employee. I returned to work. For 20 hours per week on work share program. Benefit about to end soon. My boss asked me to sign a new contract for 20 to 32 hours a week, and I refused to sign. So, you returned to work 20 hours a week. Does that mean you were working 20 hours a week, and then the other 20 was paid for by work share, or just the 20 was paid for by work share. So if you refuse to sign the contract, you may get fired, and you have a right to severance, but your right to severance is prospective, right? So it's from the date of termination forward. So what would you have earned during the severance period, whatever that is, if you would continue to be employed? And so if you were only working 20 hours a week for, say, the last year and a half, your severance calculation is going to be at 20 hours, not your historical 40 hours. So KY, like I keep telling everyone today, and I sound like a broken record, you need to give us a call. It's worth it for you to find out this specific answers to your questions after we can properly look at your individual legal position. So employmentlawyer.ca, email us at help@employmentlawyer.ca, call us at 1-855-821-5900. Thank you all for attending. It's great to see everybody. Great questions. I hope you had a wonderful holiday break. And I'm sorry I couldn't get to all your questions, but I will be back in 2 weeks. And certainly before that, so I'll see you all in 2 weeks, and answer your great questions. But before that, I'm fairly certain that we'll have another live streaming session with a different employment lawyer. So check us out. We'll have people coming on next week. Oh, there you go. Chris Justice, best name in our firm, Chris Justice, January 10th. Come join us for that on Monday, and he'll answer all of your questions with respect to employment law, vaccine mandates, all that stuff. Okay, great. Thanks for your questions. You guys